So as we said, on every session, we're going to have at least one person here around the table, which means there's a round of introduction in place today. This time we have two new people around the table who are here for the round of introduction. So we are going to do an introduction, following by a presentation by Magda and Rogier. And the drill is, from now on, just to get the idea, we do the roundtable, we do the introduction, and we finish with the speakers who introduce themselves and then start talking. Usually one speaker, these days two.
At the same time.
Most of the time.
Okay, so we're going to start with...
Hi, I'm Patricia. I'm so sorry I missed the session this morning. I'm sure it was interesting, but I made it. My background is a bit varied. So I've worked in Israel for the last 12 years in international security, but academically speaking, I have pivoted more to something called disaster science. I'm doing that at University College London in the UK and at Yale in the States. Sorry, I'm a bit sick. And I'm a business consultant as well. And in addition to disaster science, one thing that I'm focusing on are space, outer space risks, which is something we'll be talking about next week.
Right. I'm Michal Bengal. I'm the coordinator, I don't know when, I'm the coordinator of the Minerva Center for the Rule of Law under Extreme Conditions, and I'm very happy to host all of you here.
Yeah, we know each other.
Hello, my name is Gillard. I'm originally Italian, but I'm based in Belgium, where I'm doing my PhD at Cal in international criminal law.
Hi, my name is Camilo Ramirez. I'm from Colombia. I work in Special Jurisdiction for Peace and Master's Study of Philosophy and LLM in National University of Colombia. And I work some topics about IHL. Yeah.
I mean, shorter.
Hi, my name is. That's all.
Hi, I'm Ziborel. I'm from Bar-Ilan University. I work on IHL and on international criminal law, both current and historical.
I'm Eden Makidol. I'm an SJD candidate at Georgetown University in the United States, currently in Israel. And I work on NIAC, IHL. Also have a background on it. I used to work for the Ministry of Justice for the conflict unit and for the Ministry of Foreign Affairs, but now on the academic path.
Hi, my name is Kaja Kowalczewska, and I'm from University of Wrocław. I'm a postdoc researcher now doing the smartphone evidence project, but my PhD was devoted to autonomous weapon systems, so IHL total.
To znaczy, że ty się z Dolnego Śląska.
Jestem z Krakowa, but I'm not from Wrocław, but it's amazing to have someone speaking Polish as well.
Hi, I'm Julia Bai. I am a postdoc fellow at the University of Pavia in Italy, but I'm also working with a foundation which basically works in advocacy for health rights. So currently I'm working more on public health law, but first law, you can't forget it. So I got my PhD with a thesis on IHL, and that's why I'm here.
Hi, I'm Eran Beit Alachmi. I'm administrative coordinator of the center. Glad to host all of you here.
Hi, I'm Robert Marshall. I'm a research fellow here in the Minerva Center. Previously, I was a postdoc here. My postdoc is in emergency law. My PhD is in IHL. My practice is in, my practical experience is from the IDF as a military advocate general, goes for quite a long time. So.
Hi, Guy. I'm a postdoc here at the center, the Minerva Center. I'm an anthropologist studying bioethics, professional politics in medicine.
Welcome, I'm Emanuela. I'm a senior research fellow at the Oxford Institute for Ethics, Law and Armed Conflict, and I focus on the law part of that.
I'm Rogier Bartels. Sorry for not being here for the first session, but I'm happy to be here now. I work as a lawyer at the International Criminal Court. By trade, I'm an IHL lawyer, but I've been working in ICL for the last 10 years or so. And academically, I focus on IHL and ICL, but also the interplay between these two fields.
Hello again, my name is Magda Pacholska. I'm a Marie Curie postdoctoral fellow at the Austrian Institute, which is part of the University of Amsterdam, where I'm part of the Dilemma research group, which is working on military AI from both legal and ethical perspectives. And I think this is a nice transition right into the paper, so we can kickstart this. Just to double check, how much time do we have in total for our presentation before we switch to Manu?
35.
35, okay. All right, let's do it. So today we'll be talking about our latest draft paper. Those who had the time to read it will see that this is a very rough initial version of what we're hoping will be actually a much more developed paper at some point. The working title, which Roger is not very happy with, is New Technologies, Same Old Mistakes, ? Unintended Engagements as Potential Violations by IHL. This is a paper I was alluding to yesterday at the Minerva conference, the other Minerva in Jerusalem. And it is our paper. I've been corrected.
No, this was towards
the other Minerva Center. And it's actually a spin-off of a paper I presented during the last workshop last year, the one online. And because I asked Roger to comment on it and give me feedback, and we had a very interesting massive fight about it, I figured it's, clearly controversial enough to write a separate paper specifically on this issue. And you might all be wondering about the term unintended engagements. This is an umbrella term which I will define in a minute, but the bottom line is that in the discussions within the new scholarship on emerging technologies, whether it's AI-based or not, there's plenty of discussion about accountability and how to ensure accountability and make sure that there is no gap. But most of the work focuses on how to attribute responsibility or liability and to whom, and how to ensure that there are no loopholes in the system. And yet very few work, if any, examines in depth what's exactly wrongful and whether the underlying conduct was in principle wrongful in terms of being in violations of IHL. In our paper, we focus on combat activities specifically related to targeting. This is where, from my experience at least, most of the controversies lie. And it's been our impression that there is an emerging assumption, and it's often implicit, it's underlined, that when there is a unintended conduct, which is, and I'm struggling here with words because it's not necessarily always wrongful, but when combat actions result in outcomes which are undesirable and simply hit civilians or protected objects, or result in massive damage, which is disproportional to the military advantage, it is assumed that if new technologies were involved and the outcome was regrettable, let's call it, or tragic, there must have been a violation. And then the discussion often proceeds right to attribution and allocation of responsibility. On the other hand, for those of you with IHL background, this might be problematic because often in military circles, the presumption is exactly the opposite. So mistaken, unintended, accidental, call it whatever you like, conduct which was not intentional, is usually assumed not to be wrongful, not in breach of IHL. So this is the clash of these two assumptions that we're dealing with in this paper. And the core question we're asking here is whether unintended but harmful conduct, can it be a violation of IHL? And we are still struggling with how to phrase and how to structure the discussion, I'm sorry. But for now, the paper is divided in 3 substantive parts, plus introduction and conclusions. In part 2, we provide a brief overview of the type of obligations IHL imposes on both individuals and states. And then in part 3, the obligations imposed on individuals from ICL perspective are examined. Part 4, in turn, turns to state responsibility in a very traditional public international law sense from Vienna rules of interpretation. We go very old school here. And then in part 5, we're trying to bridge it all together. This is still very, very rough draft, which we hope to develop after the discussion we have during this workshop. A few clarifications, what's within the scope and what's outside of the scope of the paper, which is already 25 pages, and it's, I think, still like maybe 70% done, so it's going to be quite long. For lawyers in the room, there is no definition of what an accident, malfunction, or an error are in public international law, and especially in IHL. So to avoid confusion here, we use the word error as a failure in conduct or judgments of humans, machines, or the two acting jointly. Then malfunction is limited to machines, so only machine can malfunction. And the result of these two, or either of the two, is an accident. And then I'm still not very sure about the distinction we make for accidents, but for now we have 2 categories of accidents. The first one is called an accident in execution, and I'm going to read this one because it's very specific. So an accident in execution is a situation where a commander of a unit employing an advanced weapon system intended to target location A, which was assumed to be and assessed to be a legitimate military objective, but as a result of an error or a malfunction, you should make the sound now, we had a plan here.
So, yeah. I prevent the sound effects. No, when we were having the discussions, I always used as an example of a missile going astray, like landing out, like the missile would go, like to the other side, which was that way. So we've always referred to that as a
type of accident. So that's the first category. So the intention was to target a legitimate military objective, but because of a human error or a malfunction of a system, the true situation, he does better. The kinetic force was employed on something else. So this is what we call an accident in execution. The other type of accident is a situation where the intended target was, let's say, a building Z, I don't know why, which was designated to be a military objective. So the start is the same. The intention is in line with IHL. And the kinetic force was deployed against the intended target, but as it turned out, it was a protected object or a civilian object or a civilian. It's usually a result of bad intel, simply put. So we thought this was a legitimate military target. For lack of information or bad intel or whatever else, it was not. And this is what we call an accident in preparing. There is a confusion for those of you who have a common law background when it comes to the tort law, because this is the only field of law when we found this debatable but still an existing definition of accidents. I'm sorry, yeah, of accidents, I'm right. There's also a question of errors there. But to avoid the confusion between principle of distinction and precautions, we exclude situation which results from criminal negligence. So a clear negligence, a conduct resulting from clear negligence is not an accident for our purposes. I missed one important thing. The only term which is defined in, this is an ICL, so a very closely related term, but not in field, but not in IHL, is the term mistake, whether of fact or in law, but Roger will talk about it in a minute. So this is the only one term we're using here, which has an existing definition in the law, in black letter law as it stands today. I mentioned initially the term unintended engagements, and I think Haya might be one of the few people here who've heard this term before. A word of a background, this is a term used in the US doctrine and military practice. It's actually defined in the US DOD directive number, whatever, about autonomy in weapon systems from 2012, which is being revised and about to be released a new version. But we used it as a basis of what an unintended engagement can be. And the adjusted definition we use is on page 4 for those of you who are looking at the draft. It's right in the middle of the page. We understand unintended engagements as the use of force resulting in an outcome not intended by the targeting operations that was undesirable and resulted in persons and object being killed or harmed, which simply put resulted in outcomes IHL is trying to prevent. This leads me to the limitations of the paper. So we're not dealing with weapons, potential future weapon systems, sometimes analyzed in scholarship, which are, from our perspective, by definition and not in compliance with IHL. And this is a thought experiment some scholars engage in. We don't do that. So we'll leave this on the side. Also, to simplify the discussion, we make references to IHL often, but we really mean conduct of hostilities rules. So targeting and conduct of hostilities. We also focus on IACS, so only international armed conflict. It's also to use black letter rules of AP1. It just makes our life easier instead of having constant caveats about this is the customary phrasing of the rule and all of this. We are aware that there are situations when actors other than states could be parties, but again, for purposes of simplifying and the discussion and focusing on the core issues here, we really talk about conflicts where states are parties, so obligations incumbent on states. And I think these are all our initial limitations. Obviously, we also don't deal with related but non-legal side quests, like why accidents happen in the first place. Or the ethical issue whether IHL presumes human agency. This is a huge discussion within especially autonomous weapon systems, but not the center of our focus here. And that's about it when it comes to the introduction.
All right, so then I'll take over. So yeah, how Magda explained it, because the paper uses a lot of words that seem to have a certain meaning, but maybe don't have a specific meaning, and or do have a meaning in other fields of law. There's a lot of, as you said, caveats in the beginning, an explanation about terminology. But in essence, we're basically looking at two situations. Like you want to hit A, as she said, you want to hit A, but because of whatever way you call it, two accent, you hit B, or you want to hit A and you do hit A, but in the end, the outcome, which in both cases is not in line with IHL. It's of course possible that in hitting B, you still by chance hit a military objective. So then the outcome is actually in line with IHL. So that's also something we're not really concerned about. And we're using in line with IHL or undesirable in the sense that IHL is, of course, meant to enable the warring parties to do their job, to actually try to overcome the the enemy with military means. And for that reason, the principle of distinction is the core element, the core principle or foundation of IHL. So you can hit combatants' military objectives, but you cannot. You're not supposed to hit, at least, civilian objects. As far as proportionality rule, you can cause collateral damage, but that's the main thing. This is okay. That's not okay. So if you do hit what is not okay, civilian objects, it's an undesirable outcome under IHL. But generally, and this was the initial point of our discussion, as an IHL lawyer, you'd be like, yeah, but it's just too bad. If if this is what you manage to target, and then you hit that because the missile goes astray or because the bomb is dropped at the wrong location, that's unfortunate, but that's not a violation of IHL. So that's what we're now in this paper, rather extensive way, because we include the theory, etc. Try to consider whether those situations are indeed not violations of IHL or whether they may be actually. So in doing so, we consider the two regimes in what way you can consider accountability for violations, breaches of IHL, or at least something like that, any responsibility for the unintended or undesirable outcome. Generally, public international law has two layers or two categories of norms. One, it's like where you got the states versus states, the traditional ones. That's how it all started, of course, Peace of Westphalia. Rules between sovereign states, and then you got the newer one, mainly international human rights law, of course, state having obligations vis-a-vis individuals. But there are also some norms, some norms of international law, public international law, and the individual is the duty bearer. Now, IHL is a good example of a branch of public international law where you have both rules. So depending on the specific provision, it can either be an individual, the individual can either be the beneficiary, so the one protected by IHL, but can also be the bearer of an obligation to adhere to targeting rules. So IHL has obligations imposed on states and on individuals. And because you have this duality of the regime of obligation holders, you also have a duality of responsibility regimes. Like what do you do if there is an alleged violation? Then you have for example, through the ICJ, you have this regime to hold states accountable, and then individual criminal responsibility can be on the domestic level, but also, of course, more known is that the individual international criminal law, so international criminal courts and tribunals to hold individuals accountable for war crimes. War crimes being defined, of course, as serious violations of international humanitarian law. So there's some consequences of the fact that you have these two regimes to consider accountability. We, as Magda said, we look specifically at targeting. So that's chapter 10, maybe one. Anyway, Article 48 to...
It's part 4.
Article 48, but, okay, but Article 48 to...
AP1.
To 59 of AP1. Article 1, 1977. And in that part, so in the targeting rules, you have principle of distinction, precautions, and proportionality reflected in specific rules, codified rules. These principles were there already before. They were taken into account for targeting, but they weren't actually the black letter rules. We got them in 1977. And some of these rules specifically address states, but some are also, if you look at the wording, directed at individuals. So Articles 48, 51, 52, they're directed at states, remember? And 57, 1A1, paragraph 1A1, that has the wording, it directs at those who plan or decide upon an attack, an individual, the commander. And it's the same with the proportionality rule, which appears twice in this section of AP1. So 51.5b based on the wording, appears to be directed at states. 57 to 3 is directed at individuals. And then you have the same kind of duality when it comes to the rules related to the taking of precautions. Now, just because, and at least this is what we consider for the purpose of the paper, this is our proposition, just because there are, that a rule uses the wording those who plan or decide, so it's directed at individuals, does not mean that the state whose armed forces this individual belongs to is not also bound by this specific obligation. But if you read it in accordance with Common Article 1, which is with the respect and the obligation to respect the Geneva Conventions and IHL generally, they create binding obligations on states and on individuals. So that's an important point of departure. So, because you have two regimes, it means that you can also, for accountability, you can also use the regimes apart from each other. You can use them at the same time. If there's alleged violations, you can seek redress through, for example, the ICJ, but you can also go after the individuals who are supposed to be responsible for this. And that's perfectly possible to go to use two different avenues, but there's also differences between the two regimes, and the most important difference, at least for the purpose of this paper, the most important difference is that for international criminal law, the mental state of the individual, so the alleged perpetrator, is key in order to establish whether or not a war crime or whether individual criminal responsibility can have been can be attributed to someone, and for that reason, whether a war crime was committed. And that seems, at least on the face of it, irrelevant for state responsibility. Now, and this is, I'm talking about this now, but this is just because it then follows more, it flows into what I'll be talking about after, international criminal law, and the intent and knowledge. But this is more Magda's thing because it relates to state responsibility. So in international criminal law, you got grave breaches, the grave breaches regime in the Geneva Conventions. There's some privilege, 81, and you have the sets of obligations written in IHL, but the specific rules on when there will be jurisdiction over specific conduct or procedures, you'll find those either in domestic criminal law or
so just to interrupt you briefly, I figured it might be easier for all of you guys to have the text of especially Article 48 and 51 on display, because we'll go into text in details and it's just impossible to remember all of that. So I apologize for not having that prepared, and I also apologize for interrupting you. So go ahead.
All right. Especially on the difficult.
Your favorite, I know.
The rules of procedure you'll find in ICL or domestic criminal law. And in state responsibility, there's this thing called Articles on the Responsibility of States for internationally wrongful acts. And Magda will go into this. But what's important is that these ARS, the abbreviation, they're so-called secondary rules of state responsibility. So the secondary rules must be distinguished from the primary rules, because the primary rules specify the international obligations of the state. So for state responsibility, it's a clear distinction. IHL is the source of the primary rules, and the responsibility for the breach of which is determined in accordance with the secondary rules, and those are set forth in the ARS. It's not as clear, at least at the moment anymore, for international criminal law, because where initially you had the ICTY, well, Nuremberg tribunals, Nuremberg Tokyo was similar in the sense that it only made reference to some war crimes within the ICTY, and a very open-ended Article 3 relating to other violations of the laws and customs of war. And the Great Beach regime was included in Article 2, but so that you had to directly go to international humanitarian law to understand what actually the obligation was. So that's more similar than to the first and secondary rules for state responsibility. But by now you have the International Criminal Court's statute, the Rome Statute, which lists in Article 8 a very specific set of rules, has its own elements of crimes, and the language of those rules may not necessarily always be the exact same as the language used in the IHL treaties. And it's actually there was an issue with the ICY or the ICC in the Nataganda case where the defense challenged the charging of a certain war crime, saying like, well, this is just not a violation of IHL. And the chamber, and afterwards the appeals chamber, basically did not look so much at IHL, but looked at the wording of the statute and said, by now, because you have the underlying rules of international humanitarian law, but you also have this crime included in the Rome Statute. In this case, it was the Democratic Republic of Congo. It's a party to the Rome Statute, so international criminal law can act as like the statute can act as an international criminal code. Be that as it may, that's not necessary. Whether or not we're agreeing with this is not an issue now, but it's more as an example that it's a bit more ambiguous when it relates to international criminal law, whether you have this like first and secondary set of rules. There is nothing in IHL which specifically talks about, what Magda already said, about inadvertent engagement or the potential, how you have to look at the potential wrongfulness. That's not only in IHL, there's other branches of law where that's the case. But what is interesting in IHL is at least how the discussion seems to often go, and this maybe in part be because, as I also had like IHL lawyers just have the idea like, well, no, but that was a mistake, so that's, but we didn't mean to do that, so it's not a violation. That this may actually kind of be influenced by war crimes law, which looks at the individual, the one who decides on targeting. So that's why we first consider what happens in case of the different scenarios that we set out for targeting A and not hitting A, but targeting A, actually hitting A, but it was not what was supposed to be hit. How that would work in international criminal law. So it's in itself, it's already like the violations of the rules related to conduct of hostilities are supposed to be almost like unprovable in a court of law. That's because you need the ex ante knowledge, because that's what it's about. It's what the person who had to decide on the attack knew at the moment of launching the attack. Separately, or not separately, but it is already difficult to prove. But then also, for someone to be held criminally responsible for serious violation of IHL, you have to prove that the person acted in a certain manner, in respect to the actions that fulfill the material elements of the crime, with both intent and knowledge. Both have to be there. Use the Rome Statute here because it's properly written out in Article 30. Intent, according to the Rome Statute, means that in relation to someone's conduct, means that a person meant to engage in the conduct. In relation to the outcome of someone's act, intent means that the person meant to cause the consequence or is aware that it will occur in the ordinary course of offense. Knowledge means that a person has awareness that a circumstance exists or a consequence will occur in the ordinary course of offense. Now, without intent or knowledge, a person will not be held accountable for conduct that resulted in an outcome that's not in line with IHL or with the purpose, the aim of IHL. And international criminal liability is only attached to natural persons, living human beings. So if no one had an intent, that means that no war crime was committed. So if no one had intent, all was aware that the outcome would arise in the ordinary course of events, no war crime was committed. So in other words, purely for the purpose of IHL, no serious violations of IHL took place. The terminology serious violations of IHL then being synonymous to war crimes. And the interesting thing now, what we want to consider is that, does it then also mean that no serious violation of IHL took place for the purpose of IHL? So there was no war crime, but does that mean that there was also no violation of IHL? So the way IHL looks at alleged conduct of hostilities, so the fact that it's a conduct, these are conduct crimes, so it's only about like having wanting to engage in a certain conduct. The result doesn't need to take place, and so it doesn't consider itself as the outcome. And the fact that you can't have criminal responsibility if there's no intent or knowledge on the side of the outcome, that seems to have obscured the discussion, or at least seems to have influenced the way how people think about this. So everyone just immediately says like, no, that's not there, then you also can't have a violation of IHL. And you see that also in the way how military manuals discuss the issue, talk about the issue. In total or for me? But now, yeah, so one can wonder, like, does it mean then that you don't have, if you don't have a serious violation of IHL for the purpose of tracking individual criminal responsibility, that certain conduct cannot be seen as contrary to IHL at all? That's where Magda goes, takes it to the topic of state responsibility.
And I have 2 minutes to do that.
No.
5. All right. So for those of you who worked on IHL, I think it's a very prominent understanding and conception to look for elucidation on the meaning of different rules. To do that with the help of ICL. We have so much case law and so many scholarship around it that no, yes.
They always get it wrong, as you've just very frequently. We need to talk.
That's what we're doing here. That it's difficult to look at some of the treaty rules, completely afresh without all the ICL background and understanding we've had from before. And it is often overlooked that IHL was not originally intended to prevent only individual violations. It was intended to be binding on states, and there are explicit provisions regulating state responsibility for violations of IHL. And I'm using the words carefully here because they don't need to be serious, and it's very important. There is an implicit distinction within all IHL treaties and customary rules between serious violations and regular violations. I'm adding an adjective here, just violations. And for states can be and should be responsible for all types of violation without any qualifying adjective before that. And Roger mentioned before that for state responsibility, there is no need to establish intent. I need to clarify this a little bit. The articles on state responsibility are built on a basic principle that every internationally wrongful act of a state entails the international responsibility of that state. It seems repetitive and a little bit circular. I'm aware of that, but it's not these are not my terms. And internationally wrongful act is a term of art, and it requires 2 elements and only 2 elements. That's important. The first of them is that a given conduct always done by humans, physically done by humans, whether it's an action or omission, needs to be attributable to the state under international law. And the second element is that the same conduct must be a breach of international obligation incumbent on the state. And as Roger mentioned, the IRS, the Articles on State Responsibility, on responsibility of states, both terms are used, both abbreviations are used interchangeably. They lay down no general rule regarding intent or knowledge or any mental element whatsoever for the individuals acting in the name of the state. And establishing these is a matter for the interpretation and application of the primary rules engaged in a given case. For those of you without background in state responsibility, these rules codified, let's call it that, encapsulated in the Articles of State Responsibility, they are considered secondary rules. So they are not designed to define the content of the obligations binding on the state. So they are not aiming at classifying what states can and cannot do. In our case, this is the role of IHL. They're only focused on determining when and whether a violation took place and what are its consequences. So the attribution, allocation of responsibility and consequences thereof. In case of unintended engagements, the attribution element, so the first of the two elements, is simple because state armed forces are a state organ and their actions are always attributable to the state. There are minor exceptions to this rule. I'm not going to go there because I'm out of time already, I think. The problem is with determining when the conduct is wrongful. So when the violation of the primary obligation coming from IHL took place. And this is why we have Article 48 here. And if we could have 51 paragraph 2, that would be great as well.
Wow. Oh. It doesn't exist separate. 51.
51 paragraph 2, it exists. Believe me, it does.
You need to go back up to the.
I'm gonna go ahead here. For a bunch of reasons, it is my conviction here that state practice isn't conclusive on this issue, and for those, and we actually shouldn't jump directly to state practice when interpreting the treaty rules in this regard. For those interested why, take a look at the really heavy footnote number 74. I'm happy to go back to this during the Q&A. But our discussions when we're drafting this paper focused on, we still don't have the text, on reading all of these rules completely afresh without the ICL background, which was particularly hard, as you can imagine, for Rogier. But there is no mention of either intent or knowledge anywhere in the principle of distinction, whether in 48 or 51. And it's slightly easier for the principle of proportionality and precautions because there is an implicit ex ante assessment required for. Thank you.
Yeah, we're preempting the discussion.
Yeah, I mean, yeah.
She's going to respond.
We are also interested in your comments.
I'm warning. Sorry, Magda.
There is, I'm jumping over principle of proportionality and precautions because when you read it carefully, you can see that they clearly require ex ante assessment. And this implies knowledge, which needs to be prior to engaging in the given conduct. But there is nothing in AP1 or in AP1, 51 or 48, which suggests prima facie intent or knowledge. So when you dig deeper into scholarship on that, there is an inclination among some scholars, not some, majority, let's be honest about this one, to interpret knowledge from the terms being the object, making something or someone the object of attack or directing attacks. And we have two interpretations here. For some, these two terms.
I'm just sorry, should we look at which paragraph?
The first sentence. Okay. The civilian population as such, as well as individual civilians, shall not be the object of attack.
Okay.
And one interpretation is that being the object, making someone the object of attack is purely physical conduct. These terms are describing a purely physical conduct of aiming, well, again, this this is problematic because the choice of words here already implies a lot, and we're aware of that. The same goes for directing attacks from 48. We don't need to go back to 48. I know it's problematic. So from the perspective of treaty interpretation, we can go to travaux when there is when the meaning of the terms is ambiguous. I'm out of time. Thank you very much. No, one more sentence. I'm sorry. So when I went back to travaux, I went to the travaux of Article 91 of AP1, which says that the party to the conflict, and this is a state party in this article, a state party to the conflict which violates the provisions of the conventions or the protocols, shall, if the case demands, be liable to pay compensation. It shall be responsible for all acts committed by persons forming part of its armed forces. This article reflects almost exactly Article 3 of the 1907 Hague Conventions, and the travaux of the latter is fairly explicit in the fact that it was supposed to cover, it was supposed to oblige the state to pay compensation for the damage caused, and I'm quoting here Hans Kelsen, my favorite. So the belligerent state is obliged to pay compensation for the damage caused, even if the violation was not committed intentionally or through negligence. I don't have time to go to force majeure, but within the state responsibility regime, there are 5 excuses which prevent responsibility. One of them is force majeure. We can discuss it during Q&A because Ida is about to bite my head off. But it's also inconclusive a little bit. We have very little practice, at least documented practice, when it comes to unintended engagements and force majeure, and whether or not, and if so, to what extent it prevents state responsibility or precludes state responsibility, I should say. And I'm going to really stop here.
Well,
thank you.
I'll conclude with 2 sentences so you actually know then how this is brought together. So assuming that you accept or that you accept at least that there's a school of thought that reads the article that was just on the screen as something being made the object of attack is purely the physical, something going from A to B, and B then being made the object of attack, then these would be the conclusions if you go through the steps that we've taken. So if you have the missile that's directed at concentration of combatants or military objective, but due to the malfunction it hits a house with civilians, there's no violation of the distinction rule because it was directed at a legitimate military target. These are the 2. You wanted it to go there, so it goes there. No, this was not made the object of attack. But if what was thought to be a legitimate target turns out to be civilians and not directly participating, not directly in hostilities or civilian object, the conduct is not in conformity with the distinction rule. Whether or not the individual acting in name of the state knew at the time of launching the attack that the target was not a military objective. Because you wanted to hit this, you did hit this, and you made this therefore the object of attack. This was made the object of attack. So such a non-conformity can be classified as a breach of the distinction rule, and that would then also mean, it could lead to the conclusion that there's a violation of IHL. If it's not to be qualified as force majeure, that could also then lead to state responsibility. But that's, as Magda said, like a whole separate issue, but at least then you can have the interesting conclusion that despite not wanting to cause the effect or the outcome, just by virtue of launching the attack, you can still end up with a violation of IHL, which, as how we started off with, seems to be contrary to what people generally would say. Mano is already shaking her head. So.
Okay. Thank you very much. And before I give Mano the floor, just one simple question. If I want to hit you,
you should.
Do hit you.
Is it a violation?
Is it a violation?
of his human rights.
Is it legitimate target?
This is not a noun conflict. So,
Yes.
Yeah,
I want to look at these two guys because
Yeah, what means?
well, is it too complicated? So I'm sorry. I just and I am also Italian, and I think my body language, as you were speaking, gave my very significant discomfort away. And I don't know whether, when I started reading the paper, I was going, oh my goodness, I'm going to sound like the Yoram Dienstein of the situation. Your title troubles me. I started, no, and I quite like the initial sentence, but the unintended engagements, I was already troubled by the intention. And I'm going, oh my goodness, they're jumping to criminal law already. And then as I continued reading, and all the more so as I heard you speak, I said, okay, this is the problem. And part of me wonders if it's a generational thing. Because, and it's a pet peeve, I'm now shifting from being Yoram to being Françoise Hampson. And for the ones of you who know Françoise, one of her pet peeves is that the people who grew up in the generation of the ad hoc tribunals of the International Criminal Court only look at, I don't even know what to call it, war through the lens of accountability and in particular international criminal accountability. And we forget that, hold on a moment, there is a set of laws that is, as international law, first and foremost addressed to states, also to organized armed groups, and that with regard to certain of these rules, we have individual criminal responsibility. But the starting point is that all of the rules that are set out in these instruments, let's forget customary law for now, must be complied with. And I shuddered at one moment because the way the paper is addressing this, because it is framed through the lens of accountability. At one point, the way you were speaking somehow suggested that there were rules that somehow, because accountability for them, and in particular individual accountability for them, wasn't clear, it somehow suggested there was no need to comply with them. And I think it's just how you present things. I don't think for a moment that you're saying, oh, here's this rule, but because there isn't individual accountability for it, there's no need to comply with it. I don't think you're saying that for a moment. However, the way the paper is structured, and it was really heartening to me, Magda, that whenever you were tripped on a word, I was going, I know why you're tripping on it, because there's a problem. And whenever you were saying, I'm sorry, I'm turning my back to all of you. Whenever you were struggling with the structure, I was going, you know why? It's the way you have structured this paper is leading you to these uncomfortable analysis. Because if we had started off with, these are the rules under AP1, and states must comply with all of these rules, we would have had a very different analysis that wouldn't have left us uncomfortable, because it is not, we wouldn't be looking at whether the poor guy who actually carried out the attack that did the variety of things might or might not face individual responsibility, criminal responsibility. And I think your analysis of that is very solid. It could be that there is no individual responsibility for the attacks that go wrong, but that doesn't mean that the state didn't have very clear obligations that it might have violated. And what are the very clear obligations? And when you put them up, I was really happy. It's the obligation to distinguish at all times. It's the obligation to only direct attacks against civilians. And you've got those in the beginning. It's the question of the degree of certainty that is necessary in order to then say, okay, this is a civilian object. And you refer to Mike Schmidt's phenomenal article that even has formulas in it. You must love it, Robert. It's got mathematical formulas in.
I hate it.
Another formula's wrong.
No, there's a better one before with another.
Okay, but no, but you know, those are the questions that we should be asking about ourselves is, what is the requisite degree of certainty before an attack can be carried out by a particular party to the conflict? And what are the relevant precautions that that particular party must take in order to determine that something is in fact a legitimate military objective, or that what is the precautions that need to be taken to avoid the weapon going wrong. And if this paper had been framed that way around, so essentially with your section 4 coming right at the beginning, where you set out the obligations of the parties under IHL, and then you had section 3 where you said, okay, those are the obligations of the parties, what does it mean for the individual? You'd have got to the conclusion, the same conclusion, possibly, that the individual has not committed a war crime. But we would not be faced with this uncomfortable, you say, this odd decision that he has not committed a war crime, but there might be a violation of IHL nonetheless. And I say that's perfectly acceptable. And what the key question is here is whether the party has in fact done all that is required of the party to comply with its obligations under IHL with regard to targeting, with regard to identification of the target, with regard to taking all the feasible precautions. And I've got a lot of comments with exclamation marks as I work my way through it, but I think for me, what we all need to remember, and I was at a conference discussing this in relation to starvation, so another conversation that you and I have had. And at one point, I put up my hand and I said, hold on a moment, have I missed something? But isn't it correct that in order for something to be a war crime, it must be, the first thing we need to look at is whether the underlying rules of IHL have been violated, yes or not. And I'm glad you're all nodding, and luckily Klaus, what's his name? Klaus Kress? Mm-hmm. He was there, and luckily he said, yes, that's still the case. And I was thinking, okay, phew. And
although he has also written phew.
No, but no, because he actually stood up and said, possibly because someone said that, and he actually stood up in the conference and said, for the record, I confirm that in order for something to be a war crime, it needs to be a violation of the underlying rules of IHL.
If IHL is not applicable, you can't violate it.
No, it's more than that. It is more than that. A war crime cannot be broader, that it can be narrower than the underlying rule of IHL, so there can be, the individual criminal responsibility can be narrower than the responsibility of the state, but it cannot be broader. Metaganda
reads me. But there's two different things there. If you call something a war crime, doesn't necessarily need to mean that it is a violation of the underlying rule.
Yes,
just call something.
We can prove aggression, I would say that you're right, yes, but I'm not sure in any other
statutes and the basic IHL principle which it relies upon, it should be
of course
under to a straight line here. Because if it comes now and you add that's the issue, you can violate Article 57, for example, but still not make it a criminal offense if it was not intentional. Because if you look at it's not just a mistake, you can be neglecting some information. You should be doing something more feasibly, that were feasibly possible at that time.
But if
it doesn't go straight. Either it's
no,
but this isn't
that's also not how the yes. Well,
I'm glad we're all passionate.
One of the
because this is always what happens. It goes directly to ICL, and
but this problem which is Manu trying to
exactly.
I agree, and I write everywhere where I can that it should be based on IHL. But the fact of the matter is that you have something that's called war crimes, the Rome Statute. There's a crime in it, for example, the intentionally directing attack at peacekeepers. You won't find that anywhere in IHL.
But you can, because it's a violation of the rule of distinction. It is. It's
just.
But they are not protected by.
But
they are not protected civilians. They are not protected civilians.
So
are they parties to the conflict?
That's the problem of going to the treaties too much. There's something like customary international law, and customary international law prohibited directing attacks against peacekeepers.
That's debatable.
So
depends
it's
what
not
they're doing.
So to go only to the treaties, that's the problem in
They're not engaging, then obviously, I mean.
So, but
But the question is, can states go beyond? If they say this is just what we want to call something, and they can call it war crimes,
but they did not. The judges now say that they
Exactly.
It's not the same.
Roger, we are drifting away from the topic of the paper here.
We're not, because this is exactly what's causing at least my discomfort. You should have been commenting on it.
So happy I am. I explain why, because if I would have been saying that, I'll be claimed to be on those sides that say, oh, it's just a mistake, and that's will be your practitioner side. But it's good that it comes from someone with the opposite background. Yeah.
Right. But so this really goes to the crux of what's causing discomfort to someone who comes to IHL. This is what we were saying. We come to IHL with a different perspective. I come to it from with the objective of promoting compliance with all the rules. And what I was telling Rogier was, I think you come to it from the perspective of finding accountability for the violations. And so, I think the angle, the entry points to which we come to them shape the analysis. So,
well, we don't come from different perspectives, because I also come from the IHL perspective, and I generally criticize that people maybe do the
but you come to it.
Lens. But anyone, many people you ask, the provision not on the screen, you ask, what does it mean making the object of attack? They said, like, well, someone intended.
No, you would not. You would not. I'm sorry.
Can I clarify one thing, please? There is no such thing as state responsibility for war crimes. That's one. There is no criminal responsibility of states.
Yes,
there are no international crimes.
But that's irrelevant.
It is, because for a crime.
No, I'm sorry, Magda. You're coming to it from the perspective of, do I have a mechanism for holding states accountable?
I'm not talking
but
about
the
the
moment
term.
a state signs up to the Geneva Conventions, to the additional protocols, it undertakes to comply with the rules.
That's why I said criminal, not responsibility.
So
There's
but why are you looking at it from a criminal law perspective? I am looking at it from the perspective of the state that needs to have mechanisms in place to ensure it complies with IHL. And therefore, if we were looking at it, the questions are, do I have mechanisms in place to ensure that when I direct an attack against something, I have the requisite degree of certainty that the thing I am directing the attack against is in fact a military objective? Do I have mechanisms in place, precautions, to ensure I don't make a mistake or I don't use gaming weapons? It's not about accountability. Then it could be that they have agreed, they've both accepted the optional jurisdiction, they've agreed to give the ICJ jurisdiction. Here we got it. It's not a problem.
I think we're mixing up in this discussion the question of an available forum.
Well, you've brought that in.
No, that's not the issue.
You've
Can I
brought
say
that
also
in.
something?
That's not the issue.
I think that kind of what you were saying about the difference in how you start this whole process of thinking, whether it's from like obligation and the way that we oblige IHL or how we hold accountable the people who are doing it, is the question that I think what you're trying to say is to change the whole perspective from ex ante to post to like a futuristic approach to what we're doing. Because if your problem is the fact that I intended to target A, which was a legitimate target, but then it turned out not to be.
So it was never a legitimate target. That's the
yes.
thing.
So what you're doing is actually you're trying to make IHL to be ex post, kind of instead of ex ante. You're trying to say we should always look when we're adjudicating it, and that's why I think you're doing this mix between IHL to criminal law. So whenever we're thinking about IHL, we also need to think of what would be the potential outcome and how will that look upon us, and not whether or not we, at the moment of deciding which target to choose, we have the available knowledge to target the right one or not.
But in addition to precautions, of course, you go to precautions every time, and that's very important. But that is, and we try to leave that out of the equation because if you just look at purely factually, and then we stay entirely ex ante. It's only that you know that something was the ex ante assessment was wrong because you then afterwards you're bringing the information afterwards. But it was never a legitimate military target.
But you didn't know
because
that.
the information was.
But you didn't know about
know
it.
that.
So
But
that's what you're
knowledge and intent is relevant.
The way I read that paper, you have the problem with
But
the
we don't
ex-post.
want to talk about knowledge and intent. That's the whole point.
Exactly.
You do something. The factual thing is you launch a missile from here to here. That's done by
A
the
state.
A state.
Okay.
And it has a certain consequence. And that consequence is not what IHL meant to happen. Because
The
IHL
IHL meant
meant
something.
to only have legitimate objectives.
No. The IHL, that's not the intention of
Who's
IHL.
chairing?
No one.
No, the
I didn't
IHL
join the
intention.
conversation.
Still under your framework of response.
Yes.
No, but I think this is helpful. Is it?
I want to join the conversation. I think that a distinction needs to be made here between two situations. I'm putting aside the responsibility of an individual because we're not interested with that. We're interested with the responsibility of states now. There are norms in which you don't care about any kind of equivalent to menswear. For example, if a destruction of a religious building in an occupied territory, the destruction in and of itself, unless there are conditions of necessity, that would bring about responsibility for the state. That I agree. That on the other hand, what you are taking it one step too far, and by saying that if any civilian got hit, that civilian became an object, and therefore there was a violation. Wait. That's opposite to the most basic notion of IHL of each side carries its own harm. So you are taking it too far. Now, another thing related is that why go to state responsibility? The whole idea of Article 91 and Article 3 before it was to create something more demanding, actually, than the rules of state responsibility. To the extent, I assume that you got to the quote of the German representative.
It's in the paper, yes.
Yeah. So the whole idea was to create something that creates greater responsibility for the state. There, I agree with you, but you are taking it too far when you are turning any hitting of a civilian to a violation.
We're not saying that.
It's only, but there were the different options.
Yeah, but
No. Hold on. We really didn't have time.
You're saying that the mistake created the object.
Can I
of the
respond,
attack.
please? We really have to rush through a bunch of caveats here. There was not enough time to discuss all of the steps we go through. We came to the conclusion that there are questions and potential differences when it comes to state and individual responsibility only within the principle of distinction. Not proportionality, not precautions. It's all in the paper.
The precaution is part of the precaution duty is also to keep up the distinction. It's not, you cannot just.
Isn't this another established understanding of principle of distinction from ICL? Because when you read the IP1 as a treaty, nowhere the compliance with distinction is directly linked to precautions. It's just not there.
Let me just try to.
Come in.
First of all, Manu said I should be responding. I'm happy I'm not. I should have been elsewhere, and it was important for me to come here. It's interesting. What I was writing her in WhatsApp is saying there's a Hebrew saying that the golem raised the gated creator. That's what this analytical drill is doing. It's putting ICL in and then cutting outside IHL the same notions which made it whole. So the same fog of war, let's start from the basics. The same fog of war, the same idea that IHL is not here to eliminate any damage to civilians. It's not there for that. It's just to minimize it. It's trying the same fog of war which affects the distinction affects both the execution. It's the same issue. There is no real difference between your inability to assess whether it's a target, okay, speaking of targeting, and executing it in a proper way. This is why the precautions article deals with the whole issue from the beginning, from the distinction through the further actions that you need to do to take, and up to the question of proportionality. It's a whole game. Once you take something out of it, you just, everything collapses. All the general idea collapses here. And there is a reason why I could, in addition to everything that has been said, if you go to treaty interpretation, I'm not sure it will be correct to interpret Article 48 independently without reading it together with Article 57. It would be a mistake to say Article 57 is now an ICL issue. It's a person, it's an individual security. No, and the idea is the distinction, and with the conduct is you can also if you read it as part of the Vienna Convention, you write it, you read articles in their context, and that's the context. The context is the same fog of war, which is relevant to both distinction, both to precautions and proportionality, and you can't, and you can also explain the duty of the state is to direct it, and you yourself made the distinction between conduct in ICL, in ICL, in criminal law, between which is something with a violation by conduct, and so the direction of their attacks, again, something which is civilian, that would be the problem. But no one directed the attack in that mistake identity against civilian, and you can learn it from what directing an attack is. It's Article 57. That's the whole precaution sentence. It really bothered me because, among the other things, I was commander of the military school of law, IDF School of Military Law. So I taught those officers, and it was never saying, okay, it's a mistake, that's out of it. We always trained them saying, you have to comply with all the process. All the process should be done in the most feasible way. It started with the distinction, going to the actions, of course, the proportionality at last. Everything should be done together. So you can't just take out distinction out of the equations and say that different rules apply to states as to it or to individuals, and it's.
Can I just add? It troubles the guy in green. It troubles the former girl, nice girl from the Red Cross. So I think it's very telling that we're all very viscerally troubled by what you're suggesting. I think it's telling. I don't know whether to let Ziv come in or whether to let you respond. Respond, and then I'll make you come in, Ziv.
For those of you who were there yesterday during the second day of the conference at Minerva and at Hebrew U, were you less triggered by?
You were just discussing criminality. It just ended up being a conversation about the criminal law aspect, which was fine. It is an interesting conversation.
But the point was that instead of extending the notions inherent to ICL to capture the same conduct, there is an entirely different avenue of state responsibility to ensure accountability for the same conduct. And it might be a wiser option to capture a situation. There was a discussion in this context about Russian-Ukrainian conflict and repeatedly hitting, for example, hospitals. I think it was in the context of hospitals. And are we more comfortable extending very basic notions for individual liability rather than exploring, than going back to AP1, Article 91, and assuming that mistaken conduct for state responsibility can be a violation because of the results.
You don't need Article 91. Article 91 goes over and above the basic rules of public international law, that if something is a violation, there has been an internationally wrongful act. So to me, Article 91 in this conversation, let alone the whole discussion of circumstances precluding wrongfulness, are really a red herring. And again, I really want to emphasize, let's stop coming to this from the accountability perspective, and let's kick off with the obligations of the parties. So on the attacks, to me, the repeated attacks, you kind of say you failed in your precautions. One might have been you didn't, and I don't know whether it was a question of directing attacks or whether it was a question of proportionality. Once you might have said, okay, on the basis of the information I had as a state, I'd had the requisite degree of certainty. It happens twice. You've got to come back to your targeting loop and say, okay, what's gone wrong? But to me, we've really got to look at this from the perspective of compliance with the rules, not put the cart before the horses and look at avenues for accountability. Ziv, I've postponed you.
So, but the point that I want to make is that there can be situations in which the state would be responsible and an individual would not.
Absolutely, yes.
And that would happen, for example, if there's a collective mess up, like a series of mess ups that has led to the situation in which no specific individual could be held criminally liable, but accumulately the responsibility, like the mens rea of the collective entity, because it's not, listen, it's not, because there's something here that is beyond simply if the act was done, it's a violation, right? There's a behavior that needs to be done. And that collective behavior violated the norm. But it's not a situation in which automatically, if the weapon misfires and I hit someone else, automatically there's a violation of IHL. That is simply not what the law intended to do.
But that's what you want to do. This is a thought experiment to see whether you can still talk about this, because when you say collective, that's exactly with precautions. Intelligence is being collected by other persons, but in the end, as a state, you're responsible for the whole process.
Yeah.
But and now I'll take it a bit back, and then Magda can correct me because she knows state responsibility, and I always try to look through the lens of like tort law or whatever, because that's what I actually do know. But then, if you're cycling, you have to adhere to the traffic rules, yeah?
He's Dutch.
Cycling, or you're driving your car, you have to adhere to the traffic rules. And then you hit someone else. You didn't intend to hit this other person. You can hit the other person because you close your eyes. So you did something, you didn't take precaution, did something stupid. But irrespective, under tort law, you hit the other person. That was what happened. So you're responsible. But that, and that, but this, that's just, so this is, but this is, normally in tort law, you're like, all right, so
That's the uniqueness of vehicle tort. Yeah. Vehicle tort removed the element of intent.
That's no difference if you walk on the street. At least if you have under the Dutch version of tort law, and it's the same in France, same in Germany, if I'm correct. If you just walk on the street and
no, but there is a difference. The reason because
someone did something and the outcome was not how it's supposed to be. Bring it in the armed conflict situation. You don't have to fire. Also in an armed conflict, unless you're self-defending, you don't have to launch the missile. You design you make a list of targets you want to take out those targets. It is not. You don't have to press the button. There's never.
You're getting very existentialist about this, though.
Huh?
Okay.
But an IHL has a purpose. Yeah, like the purpose is to minimize the suffering or the damage to those who are not meant to, like be targeted. And if you take away everything else, and you were saying like, no, we shouldn't look at ICL, but most of the words you used in relation to targeting were still things like knowledge, intent, etc. And that's the whole.
No.
That's what we're trying to. That's what we're trying to consider. Like, take a step back, and then if people start talking about Article 52, they still talk about this same, like, making the object of attack. It's you only make something the object of attack if you meant that to be.
And it's not. It depends who you speak to, and we're obviously speaking to different people. And when you speak to people who focus on individual criminal responsibility, they're going to talk about knowledge and they're going to talk about intent. When I came up with that huge report on proportionality, knowledge and intent, those words did not cross anyone's lips in 18 months of project.
Can you say the last sentence again? When you were talking to?
When I wrote that report on proportionality in the conduct of hostilities, and we were looking at the rules that the parties needed to comply with, the words knowledge, the word intent did not cross the lips of any experts in 18 months. And I think, again, this is an indication of the communities of the law of war that we engage with and our engagement. And when you say people, you're in Holland riding your bicycle on the way to the ICC. I'm not.
I was in the room during those 18 months.
And the words did not cross your lips. Exactly, because we were talking about the rules.
But if you look at Article 52, and you ask someone, ask an IHL, what does it make, do not make the object of attack? Say like, the commander didn't intend to hit that.
It's not a question.
He only intended to hit a legitimate military.
No, it's about directing. And it's the basis of the...
There are different terms being used, 51 and 48.
What does directing mean?
It would mean, but if you interpret it as a whole, you should interpret it to my idea as together with Article 57 in that relation. It's not like two separate realms, two separate worlds, Article 52 and Article 57 and Article 48. They are all come to set up a general, this is what I'm trying to say, a general perspective, with a general notion about what should IHL be doing. IHL should be minimizing the damage. The same mistakes, okay, well, use your, the same mistakes can happen at all parts of the chain until the result happens. Okay, so it can happen in the identification, it can happen in the execution, it can happen in the assessment previously that in the middle of it. It can happen all over the chain. And the same idea, the same protections, the same duties and liabilities should apply all across the way. Once you take something out and say, okay, the minute someone was hurt, it's already, a civilian was hurt, it's already, the state has violated and done a wrongful act, that would be in contrary to the whole idea here. There's no, you isolate one duty, which you should not read like that. You should read it according to the Vienna Convention, I said, in the context, together with all the articles. And no one even thought about it. It's what Emanuela is saying is that this generation, looking at things through the accountability perspective, is just looking at taking just making the differentiation between persons and states, taking the things out of the IHL, and then living and then saying, oh, now you violated that part. But it's not like that. It's not that this part and this part are different or are regulating different things. It's not regulating just the state or the person. It's regulating the action.
Yeah. Can I just? I'm now chair. So we finish at 12:30. I'm going to give Ziv the floor, and then I'm going to give it back to you.
So I want to return to the point that I made earlier and give two examples. So for example, what was it? Pachu. Your Pachu. So your Pachu missile hits a religious building in an occupied territory. Automatically, the state would need to compensate. Look at the phrasing. Automatically, the state would need to compensate. An individual would not be responsible. On that,
but why?
On
what basis?
But the basis of the wait.
Why is the state being responsible here with no question? What
because the rationale is different. Because
even if you didn't know that it was a religious building.
Because the rationale is different. The idea was to give an added protection to a religious building. You cannot give that protection to every non-military target. It wouldn't work. And again, I'm saying that would violate the basic notion of IHL that each state carries the harm that occurs on its side.
What do you mean by carries the harm?
You cannot ask for compensation from the other side for harm that was done.
Oh, okay. Which
is in the legal way.
Yeah.
Not illegal.
Okay.
But
so I'm giving it back to you, John.
So because the rationale was different. The rationale here was, in this case, they were thinking about the commander. Yeah, they were thinking what would the commander or the commanders, because the state is working as a collective, would be able. You can reasonably require from them, and then from there they understood what they can require from the state, which is because they are their organs. On the other hand, the situation of the occupied territory and the religious building, they wanted to make sure that if the building was destroyed, somebody would make sure to compensate it, and they wanted also to make sure that special care would be made not to destroy the building in the first place. So the rationales were different. The incentives for creating the articles were different.
But if then I have one question and then Magda can do the wrap up. But if we change the building that was hit in the other unintended engagement situation into a hospital or a religious building, would it then change? I'm just putting it out there.
I'm not sure. I need to read the text again, but I think that in an occupied territory, of course, but I'm not sure that in unoccupied.
That's absolute liability. You hit it, it's absolute
liability. But also in occupation, the understanding that you also have a responsibility because you're the occupier, and that's what creates this enlarged responsibility.
Yeah, but before letting Magda go to the law, just from a very practical perspective, and how you then, but then you need to look at, of course, in what you don't think it is, what I'm now gonna show at the rules of AP1. So take a very old-fashioned, like a cannon. Point it this way. There's no one there. And I just turn the cannon to, in the purpose because of her criticism, it's only fair I turn it to.
I've been carrying your suitcase around all of Israel.
So.
Think about it again. Point at me. I used to be turned.
What is this? Is this directing this at Manu? Irrespective of the status of Manu. Is this directing it at Manu?
Is it the description of factual conduct?
Yeah, of factual conduct. Is this directing at Manu? Or is it only directing it at Manu if I'm like, Manu is DPHing or Manu is a combatant, and for that reason, I now want to fire a cannonball and hit her? Or is this already doing the directing and then combining it with, if I do fire the cannonball, irrespective of whether or not my intention is to hit her as a DPHer or as a combatant, is this firing of the cannon bullet that actually then hits her, making her the object?
You've got to target. You've got to target. You've got to fire the bullet.
That's precisely the one thing we tried to answer here.
You directed because she wasn't the object. Two different things. You directed the cannon at her, but she was not the object of the cannonball.
But who is the? Is it
she was
the fact that she is called Manu, or is it the figure that is sitting here?
It's the figure without the identity, I think. And I think that's what Ziv was trying to say.
But do we need the? So this is the thought experiment that we're trying to go to, in part because it seems strange that if I do all this, I do this, and I fire the cannon bullet, just the fact because, and that she is called Manu as opposed to another person sitting there. If Ido would be sitting there, I'm still doing the exact same thing.
Rogier, but I think if your article had just been about criminal responsibility, we would have all.
Yeah, but we don't want to. The problem is that that's not the issue. We know that it can
lead to individual criminal
Okay, and then if you look at...
the question is, can it lead to something else, or is it in itself?
Okay, he's about to target. And okay,
no, but this is, and that's the important thing. Why it's relevant whether you have to speak about a breach or a violation, because that's
we need the final words from Magda, because there's lunch. We can continue this over lunch, but I'd rather eat.
Okay, super briefly. One, I think we're right about one thing, and that's the fact that the discussion about IHL is very often in many different forms colored by the ICL, whether we like it or not. And even Yusuf saying, like making reference to mens rea of collective entities, even this is a term for ICL, which does not exist. I'm sorry, these are my closing words.
I was trying to, no, because you were targeted, but it's still the wording, and you also use it.
This is not a term.
What? You're not a good chair.
I have closing words here. There's no such thing as mens rea of states. End of story.
Okay, I agree.
Clearly, we have to work on the paper more. We'll have plenty of follow-up discussions with you guys over the over the next few days, here over the today and tomorrow. We will present this paper hopefully in different forms. We need to, really fine-tune a number of things. But it's funny, and this is the last sentence, that you mentioned special protection of different types of buildings and objects, because this is something we excluded from the discussion at the very beginning, because we said that if you don't know this is a cultural property, you cannot violate IHL because you didn't have the knowledge.
So what's the difference?
Okay, stop, that's check.
It's different because you use it as an example of something very clear, and for us, it was completely the opposite. This is one of the few examples when you do need to have knowledge, because you can't violate the special protection if you don't have the facts which made the object specially protected.
Thank you. This has really been. Can I just wrap up? I'm going to wrap up, and I think it's important for the young scholars, not so young. I'm sorry the anthropologist has gone, because I think it was a fascinating, stepping back from the details, I think it was a fascinating conversation, because it really highlighted the different communities and therefore the different approaches that we have to IHL. And then the other thing I want to bring up is what I love about the community as a whole is that we are so passionate about it. And we're going to get up with here and continue to be passionate and continue to be friends, which I think phenomenal. The suitcase thing is a different. Let's go and eat.
Take your suitcase.